Ladies and gentlemen of the jury, the court just, and I say this just to reference to you by numbers. We start down at the far right and run down this way, 1 through 6, upper right, 7 through 12. So, Miss Juror number 7, you are the foreperson, and the jury's arrived at a unanimous verdict. All right, if you would, please, ma'am, stand and announce that verdict on behalf of the jury.
We, the jury, find the defendant, Bla1 Allen Taylor.
This is the moment every courtroom has been building toward, the verdict. Notice how quiet and procedural everything is. That's intentional. Even in one of the most emotional moments of a trial, the court follows strict protocol. In just a few seconds, years of investigation, testimony, and deliberation will be condensed into one word: guilty or not guilty. Before we hear it, what's your prediction? Did the prosecution prove its case beyond a reasonable doubt?
For count 1, guilty of second-degree murder. For count 2, guilty of first-degree premeditated murder. For count 3,
that's a stunning series of verdicts. The jury didn't just convict on one charge. They found the defendant guilty of second-degree murder and multiple counts of first-degree murder, including felony murder. It's worth noting that some of these counts can merge for sentencing, meaning they don't necessarily translate into separate punishments. Still, from the prosecution's perspective, this is an overwhelming legal victory.
guilty of first-degree felony murder during the commission of a felony. For count 4, guilty of first-degree felony murder during the commission of a felony.
All right, if you'll turn that document in, please, ma'am. All right, ladies and gentlemen, the first-degree murder. I'll ask you if that is your individual verdict. If it is, you would indicate it is.
Now comes something viewers often overlook: the jury poll. The judge asks each juror individually to confirm the verdict wasn't the result of pressure or confusion. Every single juror answered yes, eliminating any doubt that the decision was unanimous. Imagine if even one juror had changed their answer here. It could have sent the court into an entirely different legal discussion.
It's not, you would indicate it's not. Juror number 1, is that your individual verdict?
Yes.
Juror number 2, is that your verdict?
Yes.
Juror number 3, is that your verdict?
Yes.
Juror number 4, is that your verdict?
Yes.
Juror number 5, is that your verdict?
Yes.
Juror number 6, is that your verdict?
Yes.
Many people think the trial ends the moment the verdict is read, but that's rarely true in a murder case. The next phase can be just as important. The court now shifts from deciding guilt to determining what happens next, and that's where sentencing law, victim impact statements, and mitigating factors become critically important.
Juror number 7, the foreperson, is that your verdict?
Yes.
Juror number 8, is that your verdict?
Yes.
Juror number 9, is that your individual verdict?
Yes.
Juror number 10, is that your verdict?
Yes, Your Honor.
Juror number 11, is that your verdict?
Yes.
Juror number 12, is that your verdict?
Yes.
Okay. All right, thank you very much. As you know, we'll need to discuss with the attorneys further issues in this case. Don't discuss the case any further. We'll get back with you here shortly. You can step down the hallway with the court officer. All right, Mr. Taylor, you've heard the verdict of the jury in count 1. They found you guilty of second-degree murder. That verdict as well as the other counts guilty.
Listen carefully to this exchange because it's packed with legal strategy. The attorneys aren't arguing about whether the defendant is guilty anymore. That question has been answered. They're debating what evidence the jury should hear before sentencing. Victim impact statements can be incredibly emotional, while mitigating evidence gives the defense a chance to present reasons for a lesser sentence. This is where courtroom law becomes a battle over fairness and procedure.
In count 2 of first-degree murder, counts 3 and 4 first-degree felony murder will become the judgment of the court. In terms of counts 2, 3, and 4, will be the need for further sentencing hearing. Does the state contemplate introducing victim impact statement?
Yes, Your Honor, upon the court finding that by the jury's verdict that we would be entitled to do that.
Okay. We'll take just probably a 15-minute break and let everyone settle down in terms of initial verdict. Come back and hear that proposed testimony under State versus Nesbitt, and then see Mr. Brand, Ms. Hollins, Mr. Joyner, what mitigating factors you want to submit and find that's necessary to submit to the jury. So,
The state's position is that Nesbitt only applies in death penalty cases.
what
As far
I'm
as
talking
doing-
about, as far as victim impact 403 analysis.
Under Nesbitt, if it's life without parole, there is no analysis.
So you
That
can,
is, there's no dry run unless it is a death penalty case.
you can just have whatever that may be overly prejudicial.
No, it will be victim impact under pain.
Okay. And does Mr. Brand, Ms. Hollins, you have prepared proposed mitigating circumstances?
Yes, Your Honor, I think there are mitigating circumstances, mitigating factors we would argue to the jury.
Okay. All right, if you'll get those,
I think we need a minute, probably.
okay, like I said,
Asterisk. And with that, another major legal consequence takes effect immediately. The defendant's bond is revoked. Following convictions this serious, remaining free while awaiting sentencing is generally no longer an option. The courtroom may be taking a short recess, but the case isn't over yet. Sentencing will determine the final outcome, and that's often where some of the most significant legal arguments unfold. What do you think about the jury's verdict? Let me know your thoughts in the comments.
we'll take a short break, but let me ask the state this. There are cases with, obviously with the finding in count 1, that wouldn't be considered by the jury, but there's also, I think it's Hargis versus State, that does apply to any felony murders, that your notice that you submitted, the felony murder portion, I think it's your number 2, wouldn't apply in counts 3 and 4.
Disagree, Your Honor, because it is Middlebrooks. It is not a Middlebrooks situation. It is within the legislation that amended the statute post-Middlebrooks, so that is something the state submits the jury can consider in a felony murder sentencing.
That an aggravating factor is the felony murder.
Which is based upon that aggravating circumstance, which is above and beyond just the definition of felony murder.
What do you mean by that?
Well, that the jury would have to find the aggravating circumstance that, again, that it is not a Middlebrooks situation, so that the state's position is the jury can consider that as an aggravating circumstance. That was the whole issue in Middlebrooks.
But there's some that would only apply to certain counts.
Yes, Your Honor, the age of the victim, certainly.
Right. All right, we'll take 15 minutes and then come back and hear from the defense in terms of mitigation.
Yes, Your Honor, the state would like to be heard or
Oh,
see
sure.
that. And
Yeah, let them.
we have an argument about it.
Taylor, and by law, Mr. Taylor, your bond has to be revoked, so if you'll step into the back and talk with your attorney.
Closing a 15-minute recess.